Good morning, Council and Mr. Vader. Later in this morning's session, I will announce the verdicts on a charge of first-degree murder against Travis Edward Vader. That charge reads that he, count number 1, on or about the 3rd day of July 2010, at or near the hamlet of Piers in the province of Alberta, did commit first-degree murder of the person of Lyle McCann, contrary to Section 235, Sub 1 of the Criminal Code of Canada. Count number 2, on or about the 3rd day of July 2010, at or near the hamlet of Piers in the province of Alberta, did commit first-degree murder of the person of Marie McCann, contrary to Section 235, Sub 1 of the Criminal Code of Canada. Before I announce the verdicts on these two counts, I have a number of other things which I wish to say, and it will take about 40 to 45 minutes to review my comments to you today. First, I want to thank the legal counsel involved in this lengthy judge-alone trial, which has involved the resolution of many complex issues along the way. So thank you to Mr. Finlayson QC, Mr. Stewart and Ms. Joma for the Crown, and Mr. Barish QC, Mr. Whitling, and Ms. Purser for the defense for all of your assistance. I also want to thank my court clerk for all of her assistance and support. I will be providing a set of written reasons for judgment after I have announced the verdicts. I have hard copies of these reasons ready to hand out. I've also directed the full set of reasons for judgment be placed on the Canley website once the formal verdicts are pronounced. A verdict is a finding of either guilty or not guilty and represents the end of what I call the liability phase of this trial. The second phase, if there is one, would deal with sentencing issues. On the charge of murder, Mr. Vader entered pleas of not guilty and elected to be tried by judge alone, namely me. I am the judge both of the law and I am the finder of facts, a function otherwise performed by a jury. Sitting as a judge alone, I am required by law to provide reasons for my decision, which explains the rather long document which I will issue shortly. Juries do not provide reasons for their decisions. They only deliver a verdict. The hearing on the murder charges against Mr. Vader has been what we judges and lawyers call a very long criminal trial. There had been pre-trial applications by the defense in November and December 2015, with decisions announced in January of this year. A list of those decisions and on some of the in-trial decisions are found or will be found in Appendix B to my reasons for judgment. The evidence phase of this trial began on March 7, 2016, and proceeded until the end of June, when final submissions were made to me by the lawyers for the parties. The matter was then put over until today for the issuance of my written decision and the announcement of the verdicts. During the evidence phase of this trial, 89 witnesses were called, and some of them spoke to the 208 exhibits which were entered by the Crown and the defense, many of them on scientific subjects such as DNA, telecommunication devices and text data, and as I indicated, all of this evidence and argument has now been reduced to a rather lengthy judgment of some 131 pages. Because it would take too long to read that decision, I will provide instead an overview of most of the contents of my reasons for judgment. At the beginning and towards the end, I will read from the judgment. I begin by reading several paragraphs from the introduction. On July 3, 2010, Lyle and Marie McCann, who I call the Mccanns, left their home in St. Albert on a road trip to Cultus Lake in British Columbia, where they were going to holiday. The Mccanns traveled in a large Class A recreational vehicle, which I call the RV, which towed a Hyundai Tucson SUV, which I call either the SUV or the McCann SUV. The Mccanns had arranged to meet with their daughter, Trudy Marie Holder, who I call Ms. Holder, and her daughter, who were flying to Abbotsford on July 10. The four family members that were then going to travel in the RV to Cultus Lake. The Mccanns never arrived. This was the first inkling to their family that something had gone awry. Their failure to appear at the Abbotsford Airport was very unusual. Ms. Holder immediately reported to the RCMP that her parents were missing. The Mccanns were never seen again, dead or alive. However, in the weeks that followed, the discovery of evidence linked to them began to emerge. The first item was their RV on fire near Minnow Lake, south and east of Edson. Their SUV was found in an abandoned farm near the intersection of Highway 16 and Range Road 144 west of the 5th Meridian. On July 3, the McCann's cell phone was used to communicate with persons unknown to the Mccanns. Forensic investigators located blood from the Mccanns on objects found inside the SUV. A hat worn by Lyle McCann was found in the SUV with a bullet hole and his blood on it. This is all circumstantial evidence. The RCMP investigation commenced on July 10 and soon focused on one individual, Travis Edward Vader, who I call from time to time Mr. Vader or Travis Vader. He told the police he had nothing to do with the Mccanns. This decision is to determine whether that is true or not, and whether the Crown has proven beyond a reasonable doubt that Mr. Vader killed the Mccanns and is guilty of first-degree murder under Section 231 of the Criminal Code of Canada. In my reasons for judgment, I then go on to consider a number of fundamental legal principles, and I've now gone away from my written text. I'm back into my overview. In my reasons for judgment, I then go on to consider a number of fundamental legal principles, such as the applicable standard of proof in a criminal trial, namely proof beyond a reasonable doubt, with the onus of proof being at all times on the Crown to prove this serious charge against Mr. Vader. This is also a case involving circumstantial evidence, which is subject to some special rules, and those are reviewed. My written judgment includes a lengthy review of forensic evidence recovered by RCMP investigators, including evidence about a fingerprint on a beer can, firearms residue on a hat, blood location and stain patterns, and fiber analysis. A significant part of my written judgment deals with an examination and analysis of DNA evidence, including a review of opinion evidence from Crown and defense witnesses whom I qualified as experts. I make choices as to which expert opinions I prefer and make findings of fact in respect to the DNA of the Mccanns and Mr. Vader, which had been found in various locations, on a hat worn by Lyle McCann and on some no-name cans found in the McCann SUV. Because Mr. Vader had made statements to the police about his alleged involvement in the disappearance of the Mccanns, I had made a ruling that his statements to the police were voluntary and therefore admissible in evidence. These out-of-court statements form part of the evidence in this trial, and the law requires me to perform what we lawyers and judges call a WD analysis of his involvements and also of some of the admissions which he has made. I then go on to analyze other significant bodies of evidence, including telecommunication data in respect to many telephone calls and texts, cell phone location information, and usage data. That is followed by a series of credibility and reliability reviews of 8 Crown witnesses to determine whether they are capable of belief and to assess the reliability of their evidence. This is perhaps the most difficult task for a trial judge to perform, because sometimes witnesses do not tell the truth, the whole truth, and nothing but the truth, as they swear or affirm to do. I also review evidence of other witnesses in respect to a number of stolen vehicles and witnesses called by the defense. In that part of my judgment, I also examine Mr. Vader's links to the Mccanns and some of their property. I go on to consider cell phone information, including many of the text messages put in evidence and which the Crown asserts were authored and sent by Mr. Vader. I decide whether the texts were authored or sent by him and the extent to which I may rely on the texts and phone calls as identifying the location and identity of Mr. Vader at certain points in time and place. I then analyze a number of defense theories, including partial alibis, whether a dead man, Terry McColman, murdered the Mccanns, whether a Crown witness, Dave, also known as Bandana Dave Olson, and Miles Ingersoll conspired to implicate Mr. Vader in the killings of Lyle and Marie McCann, whether the RCMP manufactured and planted a key to the McCann SUV in a stolen and burned out F-350 truck said to be connected to Mr. Vader, whether the RCMP investigators had tunnel vision and conspired to fabricate evidence and plant evidence to implicate Mr. Vader, and whether the RCMP conducted a vendetta against him. All of these reviews of the evidence in this case have led me to make a number of findings of fact based on the evidence presented at the trial and analyzed by me. I am now going to read from my reasons for judgment, commencing on page 114, paragraph 640. Some of the terms mentioned are defined terms. The times referred to in the actual judgment, the written judgment, are based on the 24-hour clock, but I have converted them to AM or PM. So the quote from my written reasons for judgment start at paragraph 640. After careful review of the evidence of the Crown and defense, I have reached a conclusion on a number of findings of fact, in addition to those already found in this decision. What follows is a review of the findings I have already identified and additional findings of fact. Prior to this review, I will restate a number of critical conclusions. 1, Mr. Vader is a drug dealer and addicted to methamphetamine. On July 3, 2010, Mr. Vader had no money, no food, and was in desperate circumstances. 3, Mr. Vader encountered the McCanns on July 3, 2010, and ended up in possession of some of their property, including the RV, the SUV key and fob, the Bogues hat, the Vopak hat, and the no-name cans. There was blood shed by both Lyle and Marie McCann, and a gunshot at close range pierced part of the Bogues hat. The location of where the bloodletting occurred is unknown. 5, Mr. Vader was the sole operator of the McCann cell phone on July 3, 2010. 6, Mr. Vader was the sole operator of the Sexsmith phone from 6:29 p.m. on Saturday, July 3, 2010, until it was seized from him by the RCMP on July 19. Going on to paragraph 641, quote, I conclude as facts that the following chronology of events occurred. June 28, 2010, Mr. Vader stole the F-350. July 2, 2010, 12:27 to 12:33 a.m., Mr. Vader is at the Bulmer residence and texts Ms. Williams on the Bulmer phone. Ms. Williams does not reply. Around 3 a.m., Mr. Vader arrives at the Steffler residence in Edmonton and frightens Ms. Steffler as he enters her home unannounced. Ms. Campbell and Mr. Vader go upstairs into a spare room where Vader sleeps for most of the time he is there. July 3, 2010. Before dawn, and while it is still dark, Ms. Campbell sees Mr. Vader leave the Steffler residence from the back steps. Mr. Vader drives away in the F-350 by himself. Around 9 a.m., the McCanns leave their home in St. Albert in their RV, towing their SUV. Around 9:30 a.m., the McCanns stop at the St. Albert Superstore gas station and Groceteria at approximately 9:30 a.m. and purchase gas and then groceries. 10:08 a.m., the McCanns depart the St. Albert Superstore and drive west on Highway 16. Around noon, again this is on July 3rd, Mr. Vader arrives in the F-350 truck at the Olson residence in Piers. He pulls the F-350 into the driveway and parks facing forward. Mr. Vader has no money, he is broke, obtains lawnmower oil from Mr. Olson and pours it into the oil reservoir of the F-350. 12:01 p.m. to 12:15 p.m., Mr. Vader uses the Olson landline 780-693-2453 to make 3 calls to the Williams cell phone 780-819-0283. Amber Williams does not answer. Mr. Vader then leaves the Olson residence in the F-350 truck shortly after 12:15 p.m. 12:15 p.m. to 2:14 p.m., Mr. Vader and the McCanns' paths intersect. Mr. Vader takes possession of the McCanns' property. 2 p.m. to 2:32 p.m., Mr. Vader uses the McCann cell phones to send 2 text messages to Ms. Williams. The first at 2:28 p.m. Quote, hey babe, it's me. How are you doing today? You know you can still text my phone. I can still receive text. I miss you so much. And again at 2:32 p.m., quote, I have been trying to call you and text you and email you and Facebook you, and I can't get in touch with you. It's me, T. 3:55 p.m., Mr. Vader phones the Williams cell phone using the McCann cell phone from the hamlet of Mackay near the Bulmer residence. Ms. Williams does not answer the phone call. Around 5:15 p.m., again still on July 3rd, Mr. Vader arrives for a second time at the Olson residence, but this time driving a different vehicle. Mr. Olson observes that Mr. Vader is driving a light green Hyundai SUV, the McCann SUV. Mr. Vader backs the McCann SUV into the driveway and parks it well back from the street. He is trying to hide the license plate on the rear of the McCann SUV. Mr. Vader now has money, gives Mr. Olson $50 and instructs him to buy cell phone time for his Virgin mobile cell phone, which I've sometimes called the Sexsmith phone in this judgment, and also some cheap beer. Mr. Olson walks to the Piers One Stop, which is close to his home. 5:29 p.m., Mr. Olson buys a $25 Virgin Mobile Easy Pin voucher at the Piers One Stop. 5:35 p.m., Mr. Olson buys a carton of Boxer beer at Piers Liquors. He uses the change from the $50 to buy some cigarettes at the Piers One Stop. Around 5:45 p.m. to 7:45 p.m., Mr. Olson first returns to his residence with the Easy Pin voucher and the Boxer beer. Mr. Vader and Mr. Olson drink beer at Mr. Olson's residence. David Olson makes some calls to Sherry Campbell, cell phone 780-517-0943, from his landline number 780-693-2453. 6:29 p.m., Mr. Vader activates the Easy Pin purchased by Mr. Olson for the Sexsmith phone and downloads $25 worth of time to that phone. 6:30 p.m., Mr. Vader immediately phones Ms. Williams using the Sexsmith phone from Mr. Olson's residence. 6:32 p.m., Mr. Vader phones Donald Bulmer using the Sexsmith phone from the Olson residence. Mr. Vader reaches Mr. Bulmer and asks him to contact Ms. Williams on his behalf. 6:37 to 11:03 p.m., again still on July 3rd, Mr. Vader and Ms. Williams engage in an extensive text message exchange on their respective cell phones. 6:38 p.m., while still at the Olson residence, Mr. Vader phones the Esther McKay residence landline using the Sexsmith phone. 7:30 p.m., Miles Ingersoll arrives at the Olson residence and parks in front of the McCann SUV. Mr. Ingersoll observes the Hyundai SUV, which is, quote, seafoam green, end quote, in color, and equipped with a tow bar on the front bumper. Mr. Ingersoll observes that Mr. Vader seems upset or something was bothering him. 7:30 to 7:35 p.m., Mr. Vader asks Mr. Ingersoll to move his vehicle, and Mr. Vader drives off with the McCann SUV and the remnants of the Boxer beer, including the cardboard carton. 7:35 p.m., Mr. Vader phones the Esther McKay residence landline using the Sexsmith phone from a location closer to Piers than the hamlet of Mackay. 10:25 p.m., Using the Sexsmith phone from a location closer to Piers than the hamlet of Mackay, Mr. Vader phones the Esther McKay landline. Moving on to July 4, 2010, around 4 p.m., the McCann RV towing the now reattached McCann SUV enters and parks in site number 8 of the Minnow Lake campground. The SUV departs, leaving the RV behind. Mr. Vader was the driver of the SUV at the time. I note there is no activity on either the McCann or the Sexsmith cell phones throughout July 4th, which was a Sunday. July 5, 2010, 12:40 a.m. to 12:48 a.m. Mr. Vader telephones the Esther Mackay residence from the Sexsmith phone from the general area of the hamlet of Mackay. Around 2 a.m., Mr. Vader arrives at the Esther Mackay residence driving the F-350 truck. Shortly thereafter, Ms. Sexsmith returns to the Esther Mackay residence to find Mr. Vader and his sister. A confrontation ensues. Ms. Sexsmith punches the F-350 and Mr. Vader drives away in that vehicle. 6:30 a.m. to 1 p.m. This is on July 5th, which is a Monday. 6:30 a.m. to 1 p.m., the RV and SUV are present at the Minnow Lake campground. The RV is backed onto Site 8. The SUV is parked on the entrance door side of the RV. After 1 p.m., Mr. Vader moves the RV from the Minnow Lake campground to a nearby closed road. Mr. Vader sets the RV on fire. 7 p.m., the burning McCann RV is detected and firefighters respond from Edson. The RV is destroyed by fire with little remaining. There are no bodies found in the ashes of the RV. 8:34 p.m., Mr. Vader uses the Sexsmith phone at some point near to Wabanum, Alberta, on Highway 16 to contact the landline at the Esther Mackay residence. July 6, 2010, which is a Tuesday. Around 2 p.m., Mr. Vader returns to the Bulmer residence in the McCann SUV and meets with Mr. Bulmer. After 2 p.m., Mr. Vader returns to Edmonton and stays at the Esther Mackay residence. July 6 to 9, 2010. Text message exchanges between Mr. Bulmer and Ms. Williams support the inference that Mr. Vader is not at the Bulmer residence because Mr. Bulmer and Ms. Williams discuss meeting at his residence in relation to property and payment of a debt. Ms. Williams does not want to encounter Mr. Vader. Ms. Williams retrieves the McCann cell phone from the Bulmer residence. Mr. Vader is at the Esther Mackay residence in Edmonton throughout that period. July 7 to 11, 2010. Numerous text messages are exchanged between Mr. Vader and Ms. Williams using the Sexsmith phone and the Williams phone. July 9, 2010. Around 12 noon, Mr. Vader leaves the Esther Mackay residence and does not return. After 12 noon on July 9, Mr. Vader travels to the Carrot Creek area, ditches and attempts to burn the F-350 truck. He then steals the clone truck at a nearby location. July 10, 2010. That's July 10. 2:01 p.m. Mr. Vader flags down Mr. Moran and uses the Moran cell phone to call Ms. Sexsmith on the Esther Mackay landline. He tells her he is stranded near Edson and needs assistance. He also asks her to put time on the Sexsmith phone. Evening of July 10, Mr. Bulmer picks up Mr. Vader near the Kiera plant on the Elk River Road and observes Mr. Vader standing near the burning clone truck. Mr. Vader set that fire. Mr. Bulmer returns to his residence with Mr. Vader. July 11 to 18, 2010. Mr. Vader is intermittently present at the Bulmer residence. Numerous text messages are sent and received by Mr. Vader using Mr. Bulmer's cell phone to various persons on July 11, 12, 17, and 18. July 16, 2010. The SUV is located on the Sampson Roeder property and is seized by the RCMP. July 17, 2010, the burned out F-350 truck is seized by the RCMP at the Encana well site north of Highway 16. July 19, 2010, Mr. Vader is located at the Bulmer residence. He tries to flee and is detained by the RCMP on outstanding charges. Paragraph 642. With these findings of fact, I now proceed to determine whether or not the Crown has established beyond a reasonable doubt that Mr. Vader is guilty of first-degree murder or a lesser and included offense. And that's the end of that quote. I'm now going on to the next part of my decision, which involves the analysis and the review of a number of issues. I am not reading all of the paragraphs under those issue headings, just some of the conclusory paragraphs. So again, quoting from my written reasons for judgment. Issue number 1, are the McCanns dead? Starting at paragraph 648, second sentence. The assembled facts lead to only one reasonable conclusion. The McCanns are dead. I find it entirely implausible that the McCanns survived whatever happened in July 2010, but were then able to and chose to conceal their survival. Paragraph 649. The defense also complains that the Crown has not provided evidence of the time, manner, or cause of the McCann's death. That is not necessary, nor are these elements a part of the offense in question. What matters is whether the Crown has proven the only reasonable inference is that A, the McCanns are dead, B, Mr. Vader caused those deaths, and C, that Mr. Vader had intended to kill or cause bodily harm and was reckless as to whether death was the consequence. Going on to issue 2, did Mr. Vader have a motive to target the McCanns for legal purposes? Paragraph 653. I conclude there is no alternative and reasonable theory that would lead Mr. Vader to interact with the McCanns. He wanted their property for his own use. I think it says much that the plausible window for Mr. Vader's interaction with the McCanns is within a narrow 5-hour period on July 3, between his first and second visits to Mr. Olson's residence. On his first visit, he was penniless, unable to contact Amber Williams by his own means, and borrowing lawnmower oil for the F-350 truck. Several hours later, Mr. Vader has used the McCann phone and reappears at the Olson residence in the McCann SUV with cash for beer and the purchase of cell phone subscription time. His robbery had harvested the resources Mr. Vader wanted to satisfy his immediate needs. I find beyond a reasonable doubt that Mr. Vader's motivation to interact with the Mccanns was to steal their property. Paragraph 654. I stress in coming to this finding, I am not concluding that Mr. Vader must have aimed to rob the Mccanns because of his, quote, bad character, end quote, that he is the, quote, kind of person, end quote, who commits robberies. I come to this conclusion because Mr. Vader had needs which would be satisfied by the robbery, and because he had a pattern of committing thefts to satisfy his needs, particularly when it came to vehicles. The Mccanns and their property were likely nothing more than a target of opportunity, an opportunity that Mr. Vader took. Issue number 3, was Mr. Vader involved with the Mccanns' property? Paragraph 665. I therefore conclude that the doctrine of recent possession has no direct relevance to Mr. Vader's guilt or innocence for the offenses charged, but does raise a reasonable inference that Mr. Vader stole the Mccanns' property, which I find is a fact and beyond a reasonable doubt. There is no reasonable, innocent inference to explain Mr. Vader's possession of the Mccanns' property. Paragraph 666. This is another element of the factual matrix, which in turn may form the basis for the Crown to prove its case beyond a reasonable doubt. Theft is relevant in 2 senses: motive and the probability of violence. I turn next to the latter point. Issue number 4, were the Mccanns victims of violence? Again, I start at the second sentence of paragraph 674. While I have concluded that a firearm was used during the interaction between Mr. Vader and the Mccanns, and that firearm caused the hole in the Bogue's hat, I cannot establish who fired the gun or at whom, and the blood drop and spatter pattern on the Bogue's hat does not suggest the bullet that passed through the hat and caused an injury to someone wearing that hat. The blood, largely from Lyle McCann, is on the top of the hat. Paragraph 675. My conclusion on that point, however, does not affect my conclusion that violence occurred in the interaction between the Mccanns and Mr. Vader. There was bloodshed. A gun was discharged. While I cannot reconstruct the exact detail of what occurred, I also have no doubt about the overarching relevant fact. The Mccanns were victims of violence. Mr. Vader inflicted that violence. The Mccanns suffered bodily harm. The presence of their blood makes that obvious. And then carrying on, continuing to quote from my judgment, the next header is Mr. Vader committed homicide, paragraph 676. Linking the facts I have found, there is no question that Mr. Vader committed homicide. The Mccanns are dead. They were the subjects of violence that caused bloodshed. Mr. Vader's biological material is mixed with blood from Lyle McCann. Mr. Vader's motivation to interact with the Mccanns was theft. Forensic and witness evidence links Mr. Vader to the Mccanns' property. Paragraph 677. Mr. Vader caused what happened to the Mccanns. The Crown's evidence and the inferences I have drawn from that evidence do not permit a detailed reconstruction of the circumstances that led to the Mccanns' death and how Mr. Vader caused those deaths. However, I conclude beyond a reasonable doubt that Mr. Vader, in one manner or another, caused the death of Lyle and Marie McCann. My next step is to determine the legal implications of that fact. And I'll repeat this twice. My next step is to determine the legal implications of that fact. The next heading is first-degree murder, paragraph 678 of my judgment. The Crown seeks to have Mr. Vader convicted of first-degree murder. To come to that result, I must conclude that the Crown has proven beyond a reasonable doubt that either, 1, the Mccanns homicide was planned and deliberate, section 231 sub 2 of the Criminal Code, or 2, the homicide occurred while Mr. Vader was committing or attempting A, a sexual assault, B, a kidnapping and forcible confinement, C, a hostage taking. Paragraph 679. The Crown has entered no evidence to support the various 231 sub 5 alternatives. That leaves the question of whether the homicides were planned and deliberate. Paragraph 680. The Crown's argument is that one of the two Mccanns was executed as a witness. The Crown proposes a, quote, most likely, end quote, scenario for the interaction of Mr. Vader and the Mccanns, where Mr. Vader engaged in a violent confrontation with the Mccanns during a robbery. And this is a lift from, I'm quoting from the Crown's argument. Mr. Vader was in the process of stealing from them, and that during the violent confrontation, Mr. Vader murdered either Lyle McCann or Marie McCann. Given the age and strength of the surviving McCann, it is submitted that that person would have posed no threat to Mr. Vader and that he murdered the survivor to eliminate them as a witness. The Crown concludes the subsequent execution would be, quote, a cold and calculated decision that would still meet the test of planning and deliberation, even if it was made after the violent confrontation commenced. The Crown, I'm going on paragraph 681, the Crown cites the Queen against Green, I won't read the cite, paragraph 13 for this, quote, execution of a witness, end quote, rule. Quote, the emotionless killing of a witness to a prior crime under no higher motive than to silence him or her is conduct which lies comfortably with a finding of murder in the first degree. The act as here imports volitional choice, a calculation of self-interest, a weighing of the consequences of killing as opposed to not killing, and an assessment of the means and opportunity available for its successful completion. And that's the end of the quote. I'm actually going to skip over an analysis of, which I carry out in my judgment, of that decision in the Queen against Green. Go on to paragraph 684. The problem with the Crown's theory is simple. There is no evidence to support that the homicides occurred in the manner the Crown has proposed. It is a theory. For me to convict Mr. Vader of first-degree murder following the Crown's theory, I must conclude that there are no other reasonable alternatives than one death, time to make a plan that was, quote, conceived and carefully thought out, end quote, the Queen against Nygaard, an act that was, quote, intentional, end quote, considered, not impulsive, end quote, the Queen against Turning Robe, then the killing of the second McCann. Paragraph 685, the problem is there are other reasonable possibilities that can take us from a robbery gone bad to that of two dead senior citizens. The most obvious is that Mr. Vader encountered the two McCanns together while trying to commit a robbery. The McCanns both physically resisted Mr. Vader. That fight escalated, and in that struggle, both McCanns were fatally injured. This is quite plausible, particularly since I have evidence of a firearm being used. Given that, I cannot conclude beyond a reasonable doubt that Mr. Vader killed one or both of the Mccanns in a planned and deliberate manner. Paragraph 686. That is not to say that the Crown's proposed scenario could not have happened. It is entirely possible that the Mccanns were both restrained during a robbery, then executed sometime afterward. Perhaps the Crown's theory is correct. The problem is there is no evidence on which to prefer any of these alternatives. The next heading is second-degree murder or manslaughter, beginning at paragraph 687. The culpable homicide of Lyle and Marie McCann is either a murder or manslaughter. Section 22 sub 4 of the Criminal Code. A homicide is murder, Section 230 of the Criminal Code. If Mr. Vader killed the Mccanns, 1, during commission of a robbery, Section 343 of the Criminal Code. 2, if Mr. Vader intended to cause bodily harm to the Mccanns to facilitate the robbery or his flight after committing the offense. And thirdly, bodily harm was inflicted and that bodily harm led to the Mccanns' deaths. Paragraph 688. I have concluded beyond a reasonable doubt that Mr. Vader intended to and did steal property from the Mccanns. I have also concluded beyond a reasonable doubt that the Mccanns experienced bodily harm, as is demonstrated by the forensic blood evidence. The Mccanns are dead, and the only reasonable inference I can draw is the bloodshed evidence indicates the Mccanns were killed by Mr. Vader's actions. Paragraph 689. The blood-stained no-name cans and Bogue's hat also established that the bloodshed occurred prior to the theft of at least some of the Mccanns' property. The Mccanns were injured, bled on these items, and then the items were moved to the SUV by Mr. Vader. This proves beyond a reasonable doubt that at least some violence directed by Mr. Vader to the Mccanns occurred to facilitate the robbery. Paragraph 690. Last, I conclude beyond a reasonable doubt that Mr. Vader intended to cause bodily harm to the Mccanns. The scope of the blood evidence establishes that Mr. Vader had no other reason to apply force to the Mccanns except to further his criminal acts. Paragraph 691. From the evidence I have accepted and based on the inferences drawn from that evidence, I conclude beyond a reasonable doubt that Mr. Vader committed murder. A murder is either first or second degree murder, Section 231 sub 1 of the Criminal Code. The killing of the Mccanns was not a first degree murder. It is therefore a second degree murder. I now come to the verdict stage. Mr. Vader, please stand up. On the 2 counts of first-degree murder, I find you, Travis Edward Vader, not guilty. But Travis Edward Vader, I do find you guilty of the lesser and included offense of second-degree murder of Lyle and Marie McCann near Piers, Alberta, on or about July 3, 2010. I enter convictions on each of those verdicts on count 1 and count 2 in the indictment. You may sit down, Mr. Vader. Under the Criminal Code, the mandatory sentence on a conviction for second-degree murder is life imprisonment with a minimum of 10 years before eligibility for parole occurs. However, before that life sentence is imposed by me, it will be necessary to consider Section 754.4 of the Criminal Code to determine a period of parole ineligibility of between 10 and 25 years. So, counsel, we will now discuss the timing of that inquiry. I can tell you, Mr. Vader and counsel, that I will be directing the preparation of a pre-sentence report. I will also raise the question of a forensic assessment of Mr. Vader, and we can discuss my reasons for requesting that in due course. However, before we go on to those discussions, I would like to give all involved an opportunity, including Mr. Vader, an opportunity to review my written reasons for judgment, which again is the actual judgment in this matter apart from the verdicts which I have just announced. I propose to adjourn and return to this courtroom in 1 hour or sooner if counsel wish. Defense counsel may meet with Mr. Vader in the cells. So I understand there are copies of my written decision somewhere here. So I'll ask you, Madam Clerk, to hand those first to Mr. Vader and to counsel. And then I did make, I hope, made sufficient copies that there'll be enough to go around to the assembled. Thank you. So thanks, counsel. We're adjourned.